Your Honor, we've reached a plea agreement in this matter.
All right. Appearances for the record. I apologize for that.
Jake Wisty on behalf of the people.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Mr. Jones. He's present at council table. He's standing to my right.
So you are Jeffrey Jones?
Yeah, we do.
All right. Mr. Wisty, the indication is you reached a plea agreement today. If you want to indicate that for the record.
Yes, Your Honor, we've reached an agreement where defendant will plead guilty to an amended count one. It will be amended from domestic violence third offense notice to domestic violence second offense notice. The PAC code for that is 750.813. It is 1 year and or $2,000. There's a Killebrew agreement of a jail cap of 200 days to run concurrent with the sentence Mr. Jones is currently serving involving a circuit court matter. And there is an agreement that people will not pursue any PA 53 violations for any contacts that occurred before today's date. That's the extent. Oh, and count two would be dismissed.
Okay.
As well as the habitual offender, which would be applicable as this is now in this.
Okay, will not pursue any PA 53 prior to this date. Of course, dismiss the DV3.
Yes,
DV3 and any habitual.
yes. It would be amended to a DV second. Whatever's cleaner for the court's record. I
All
would
right.
add a counter amended.
So I think most likely it would be to add, what about the count two? Is that to be dismissed
Count
also?
two will be dismissed.
So we add a count three of DV2, dismiss count one and count two.
Yes, Your Honor.
All right, I'm going to restate that for the record, Mr. Sarks, and then you can indicate. My understanding is we'll amend it to add a count three of domestic assault in the second, that being a 1 year and or $2,000 pursuant to 750.813. There's a Killebrew agreement of a 200-day cap and any time to run concurrent with the circuit court case. Further, there's a Killebrew agreement that you will not pursue, the people will not pursue any PA 53 violations that happened prior to this date. There's also an agreement to dismiss count three and any habitual count. I mean, dismiss DV3, which is the count one, and any habitual notices. Is that a fair and accurate statement, Mr. Sarks?
Yes, Your Honor.
All right. Just want to make sure I understand that. All right. May I inquire your client of his advice of rights?
Yes, Your Honor.
All right. Mr. Jones, you've had the opportunity to hear the negotiations in this case,
Yeah.
correct? Right, and you understand that you'll be pleading guilty to an amended count 3 of domestic assault in the second degree. That is pursuant to 750-813. Maximum penalty you could get is 1 year and or $2,000. And then there is a Killebrew agreement. So if I did not follow that agreement, you could withdraw your plea. Do you understand that?
Yeah.
All right. So to restate it for the record, the Killebrew agreement would be 200-day cap to run concurrent with your circuit court case, and that the people will agree not to pursue any PA 53 contempt violations happening before this date. Do you understand that, sir? In accordance with this, we'd also dismiss the count 1 of domestic assault in the third and any habitual notices in regards to this file. Do you understand that? All right. You've signed an advice of rights and a plea information. I have that in my hand. You signed that, sir? All right. So I will not go through your trial rights in this case, indicating what your advice of rights and plea information is. I will tell you that you have 3 constitutional rights that I'll notice you have. You have the right to remain silent. Anything can be used. Anything you say will not be used against you in trial. Do you understand that? You have the right to assistance of counsel. You're, of course, represented by Jacob Sarch today. He would be here to cross-examine and contest any charges brought against you in this case. And you have the right for the people to prove beyond reasonable doubt that you're guilty in this case. Do you understand that, sir? All right. I'm going to have you raise your right hand. I know I don't have to do this, but I do it anyway. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. So it's your understanding today that you're waiving your trial rights and you're pleading guilty because you are guilty. Is that right, sir? All right. I'm going to bring you back, your attention back to March 5th, 2022 at the offense location of Miller/Wise in the city of Lansing, Ingham County, state of Michigan. Were you at the Miller/Wise address in the city of Lansing on March 5th, 2022? And you know a Jamila McCoy. And is Jamila McCoy a person with whom you have a child in common? All right. Please indicate to me what you did in regards to Jamila McCoy, which makes you guilty of the domestic assault on March 5th, 2022 in the city of Lansing.
I pushed her.
Okay, you pushed her. And that push was an offensive touching against her. And you did not do so in self-defense. Okay. I find that the factual basis of the offensive touching domestic assault, there is a prior notice that we'll do for the 1 year. So I'll take notice the defendant was previously convicted of domestic assault on March 10th, 2021. That was in the 30th Circuit Court for the Ingham County, making this a 1 year. I will also notice that is the 1 year and or $2,000. Any questions as to the factual basis, Mr. Wisty?
No, Your Honor.
Anything, Mr. Sarks?
No, Your Honor.
All right. I find the factual basis to be knowing, voluntarily, and accurately made. I am going to direct the defendant to probation, of course. So probation will come down and talk to you, sir. And they will ask you a bunch of questions, and they'll set up a report for me. They'll understand the plea agreement. They'll understand anything in regards to the plea agreement. With that understanding, they'll prepare a report for me, and then we'll see what options are available to us at the date of sentencing. Okay. Sentencing date?
April 11th at 1:30.
April 11th at 1:30 will be the sentencing date. Mr. Sarts, how much time does your client have in right now? You know, will he be incarcerated at the sentencing date?
Yes, Your Honor.
All
He's
right.
under sentence right now.
He's under sentence right now.
Yes.
All right. It's my understanding that, so I'm not going to worry about any type of, there does seem to be a PA 53 violation that is indicated. It's dismissed as a part of this agreement. Is that
Yes,
correct?
Your Honor.
So Mr. Jones, you understand that while you're incarcerated, you're supposed to have no direct or indirect contact with Jamila McCoy. You understand that, sir? Okay. You understand that And it's the onus is all on you. All right. So if Miss McCoy calls you 100 times, if she sends people that you can't have any contact with her. If you do, I'm going to find out about it, and then I'm going to have to do something about it. And your 200-day withdrawal of plea is at risk. Also, I'm going to consider putting you on GPS during the term of your probation, things of that nature. Okay. All of that's at stake here. So the best way to protect yourself is to keep in no contact with her at all. Not through family, not through friends, anything along those lines. Do you understand that?
Yeah.
All right. You seemed hesitant there. There should be no hesitance. This is to help you because the alternative is for me to do something about it. All right. All right. Anything else for the record, Mr. Wisty, in docket 22-00887?
No, Your Honor.
Anything, Mr. Sarts?
Nothing further, Your Honor. Thank you.
Okay, thank you. That's all for the record. I'll put the advice for rights in the file.
What the sentencing date was again?
April 11th.
April 11th at 1:30?
Yes.
Okay.
Thank you, Your Honor.
Thank you, Mr. Sarts. I think it's okay. What's Miss James here?
She is here. For Harding.
We can move Mr. Hickson.
So we're on the record in docket 23-00100. That is people of the state of Michigan versus Tyshawn Hickson. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Attorney Derek Escher, Office of Public Defender, on behalf of Mr. Hickson, who's standing to my right.
All right, and sir, you are Tyshawn Hickson?
Yeah.
All right. This is the time set for preliminary examination today. Mr. Wisty, how are we proceeding?
Your Honor, the parties are going to agree to an adjournment today. The reasons being one of the people's witnesses is on a pre-planned vacation. I believe the defense wanted to look into some more discovery issues. Requested it be set for a date after February 6, 2023. That is the date when our witness returns.
Date after February 6th, 2023. So you have a witness that's out on vacation or out. And then there's some discovery issues that did you want to state any of that for the record?
Yes, Your Honor. I think we discussed it at the PCC when we were leaving this on, that we may ask for an adjournment because of evidentiary or investigative issues. Primarily, we're trying to interview a witness that was in the vehicle who says the weapon was his. So we're trying to see whether or not he's going to stick with claiming the ownership of the weapon.
All right. I have noticed that your client has not waived his right to a prelim within 21 days of arraignment. Is he going to do so today?
That is correct.
All right. So I will also. All right. May I inquire of your client of his waiver of the 21-day rule?
Yes, you may, Your Honor.
All right. Mr. Hickson, you understand that you have the right to a preliminary examination within 21 days of your date of arraignment. Do you understand that, sir? And a preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed the crime in this file. You're, of course, represented by attorney Mr. Etheridge, and he would cross-examine and contest any charges brought against you at that time. Do you understand that? So if you waive your right to a prelim within 21 days today, you won't be waiving your right to a prelim. You'll only be waiving your right to a prelim within that 21-day period. And that will give both parties time, A, for discovery, and B, to get a witness here. Do you understand that? Is it your intent today, and do you want to waive your right to a prelim within 21 days? All right. I find that the waiver of the 21-day to be knowing, voluntarily, and accurately made. And we'll reschedule this prelim after February 6th for,
It's February 9th.
is February 9th enough time, Mr. Wisty?
That should work. Your Honor.
Okay,
February 9th at 9:30, please.
February 9th at 9:30 for preliminary examinations. Anything else for the record in docket 23-00100? Mr. Wisty,
No, Your Honor.
anything, Mr. Etheridge?
Your Honor, I think that's enough time for us as well. We've already made contact with the witness's parents, so we've already had contacts. Hopefully, the interviews and stuff will be done by that date. So I think
All
that
right,
should-
and if not, let Mr. Wisty know and he can contact the office, okay?
Yes, Your Honor.
All right. Mr. Hickson, you're all set. Thank you for your appearance today. Ms. Housefield, how are you?
We could approach, Your Honor.
Sure,
Your Honor, I'm doing well. How are you?
good. This is Sir, in the Ingham County Sheriff's Office south of Raymond, could you identify yourself? Maybe not. Sir, from the Ingham County Sheriff's Department, can you identify yourself?
James Harden.
No, yeah, thank you, Mr. Harden, but you're not in the Sheriff's Department. Ingham County Sheriff's Department.
Oh,
Sir, could you identify yourself? Not on the tablet. Ma'am, I know who you are. You're Juanita Edwards. Sir, what is your name?
My name is Leandre Odes.
You're gonna have to speak up, sir. I can't hear you.
My name's Leandre Odes.
Okay.
That's my client.
Oh. Mr. O, stand by and we're going to place your probable cause conference. We have your attorney here. We're going to place it on the record in a few minutes. All right.
Yes, Your Honor.
Okay. So we're on the record in docket 22-03237. That's people of the state of Michigan versus James Harden. Will the parties please introduce themselves for the record?
Chief Wisty on behalf of the people.
Good morning, Your Honor. Gidget James on behalf of James Harden, who is also present by Zoom.
And sir, you are James Harden.
Correct.
You can hear me all right, Mr. Harden?
Yes, I can.
All right, this is the time set for a preliminary exam, probable cause conference in this matter. Mr. Wisty, how are we proceeding?
Your Honor, at this point, there hasn't been an offer extended. There has been some discussion with defense counsel's office regarding Mr. Harden producing some evidence through the police department on his phone. I would defer to defense counsel whether or not we want this left on or the status of any investigation they may be conducting.
All right, Ms. James, status of this case and whether we want it to left on and any discovery issues?
Thank you, Your Honor. Your Honor, we have reached out. We're waiting on a phone dump on Mr. Harden's phone. We also are waiting for some correspondence from his job that we think would be very helpful. So at this time, we're asking for a short adjournment of the exam. Additionally, we just subbed in on this yesterday. Mr. Harden is prepared to waive his right to have that exam within 21 days.
Mr. Wisty?
People would also waive in those circumstances.
All right, Ms. James, may I inquire of your client of his waiver of the 21-day rule?
Yes, please, Your Honor.
All right, Mr. Harden, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment. Do you understand that, sir?
Yes, I do.
And a preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. Do you understand that, sir?
Yes, sir.
You, of course, are represented by Attorney Gidget James, and she would be available to cross-examine any witnesses and contest any charges brought at that hearing in your defense. Do you understand that?
Yes.
It's my understanding that it is your wish today to waive your right to a preliminary examination just within the 21-day period. You won't be waiving your right to a prelim in general, just to the prelim within 21 days in order for some discovery issues to take place concerning this matter. Is it your intent today and your wish to waive your right to a prelim within 21 days?
Yes, Your Honor.
All right, I find the waiver of the 21-day to be knowing, voluntarily, and accurately made. Mr. Wisty, you also waive your right to prelim within 21 days.
Yes, Your Honor.
All right, and we will reset. So. And we will reset the prelim for,
It's February 9th.
okay, so we have a February 9th date available and a February 16th date available. Which would you prefer in regards to the discovery issues?
People have no preference. I would defer. I believe that the phone dump can be accomplished relatively quickly, so I think February 9th would work.
All right, Ms. James, do you have a preference as to the 9th or the 16th concerning some of these discovery issues?
Your Honor, I think that the 9th would work better for us.
All right, so we will set the prelim for February 9th at 9:30. So, Mr. Harden, your next date is February 9th at 9:30. Please keep in contact with your attorney, Gidget James, in regards to that preliminary examination. Anything else for the record in docket 22-03237, Mr. Wisty?
No, Your Honor.
Anything, Ms. James?
No, Your Honor, thank you.
All right, thank you. Ms. James and Mr. Harden, you're free to leave the Zoom courtroom. Thank you for your appearance today.
Thank you.
And Your Honor, I believe we can move Ms. Edwards' cases.
All right, that's Ms. Who's the defense attorney on
Mr. Hess.
Mr. Hess? Okay.
Your Honor, these will both be left on for prelim. People have no preference whether or not we go on the record for that.
All right. Well, since we're here, we'll put it on the record.
And Mr. Wisty, just for your information, Mr. Olds is also present by Zoom, so we're ready to proceed with this probable cause conference as well. I haven't even had a chance to meet with him. I just got appointed the other day, so we'll just leave that one on.
right.
So we're on the record in docket. There's two of these. You get the other one too, 5-3. So we're on the record in dockets 22-3264 and 22-303253. That's people of the state of Michigan versus Juanita Edwards. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Edward Hess on behalf of Ms. Edwards. I'm in the courtroom. Ms. Edwards is appearing by remote video conferencing from the custody of the Ingham County Sheriff.
Thank you. And ma'am, you are Juanita Edwards?
Yes, sir.
All right. And you can hear me all right, Miss Edwards?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference on both of these files. Mr. Wisty, how are we proceeding today?
We'd like both files left on for preliminary examination.
And is that an accurate statement, Mr. Hess?
It is, Your Honor. The prosecution has not extended any plea offers in this matter. I will meet with Ms. Edwards in the jail to discuss her case with her, but at this time, I will be ready to proceed with preliminary examination at the scheduled date and time. Thank you.
All right, at this time, the preliminary examination is scheduled for February 3rd, 2023 at 8:30 for both files. Ms. Edwards, your attorney, Mr. Hess, will be there to talk to you about the preliminary examination left on for next week. Anything else for the record, Mr. Wisty, in either one of these cases, 22-03264 or 22-03253?
No, Your Honor.
Anything else, Mr. Hess?
Nothing further. Thank you.
All right, Ms. Edwards, keep in contact with your attorney, Mr. Hess, and we'll see you next week. All right, ma'am?
Then, Your Honor, we can move Riggins and Olds. I
All
believe
right.
Olds is in South.
All right, so you're all set, Ms. Edwards. Let's do Mr. Riggins. Let's call that case. So we're on the record in docket 23-00125, people of the state of Michigan versus Jeremy L. Riggins. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Edward Hess on behalf of the defendant. The defendant, Mr. Riggins, is appearing by remote video conferencing from the Community Mental Health Bridges Crisis Unit this morning, Your Honor.
All right, thank you. And sir, you are Jeremy Riggins?
Yes, Your Honor.
All right, and you can hear me all right, Mr. Riggins?
Yes, Your Honor.
All right, thank you. Mr. Wisty, this is the time set for a probable cause conference. How are we proceeding?
Your Honor, we'd like this left on for the preliminary examination.
And is that an accurate statement, Mr. Hess?
It is, Your Honor, to more complete that statement. As I just told the court, Mr. Riggins is in the Bridges CMH Crisis Unit at this time. He plans to stay there until he receives a treatment plan and until he is stabilized. And there is a plan for Mr. Riggins to be admitted to a long-term rehabilitation facility thereafter. And I will be getting an update from the treatment team later today. As such, Mr. Wisty has reached out to me and informed me that once we get a fuller picture of Mr. Riggins' treatment needs, that the prosecution may be willing to extend an offer in this matter. So we are working to get all that information to Mr. Wisty as quickly as possible. And then it is my hope that prior to the scheduled preliminary examination date, that this case could be resolved.
All right.
Understanding that, Your Honor, however, there's no official offer at this time, and we will be prepared for preliminary examination if necessary.
All right, thank you. Ms. Riggins, you understand that this is going to be held on for preliminary examination on February 3rd of next week at this time. Negotiations are continuing, including some information concerning your treatment plan at the community mental health center. Do you understand all that, Mr. Riggins?
Yes, Your Honor.
All right, thank you. Anything else for the record in docket 23-00125, Mr. Wisty?
No, Your Honor.
Anything else, Mr. House?
Nothing further. Thank you.
All right, thank you. So, Mr. Riggins, we'll see you next week, possibly. keep in contact with your attorney, Mr. Hess, and you're free to leave the Zoom courtroom. Thank you.
Thank you.
It's Mr. Olds, right? Right, we're on the record in docket 23-00129. That's people of the state of Michigan versus Leandre Germain Olds. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Edward Hess on behalf of Mr. Olds. Mr. Olds is appearing by remote video conferencing from the county jail.
And sir, you are Leandre Germain Olds?
Yes, Your Honor.
All right. And you can hear me all right, Mr. Olds?
Yes, sir.
All right. Just the time set for preliminary probable cause conference in this matter. Mr. Wisty, how are we proceeding?
Your Honor, we'd like this left on for preliminary examination at this time. An offer has been extended. My understanding is defense counsel wants some time to discuss it with their client. So that's where we're at today.
All right. And is that an accurate statement, Mr. Hess?
It is your honor. To complete the statement, the offer that has been extended by the prosecution is an offer to plead guilty to 1 count of home invasion, 3rd degree, as a habitual second offender. And I was just appointed to Mr. Olds the other day. I have not yet had a chance to meet with him. I will meet with him as soon as possible so that we can get caught up on his case, Your Honor. Thank you.
All right, Mr. Olds, you understand that this preliminary examination is being left on. You have been appointed a public defender, Mr. Hess, in this case, and he's going to talk to you about any negotiations that have been the course of action in this file. Do you understand that, sir?
Yes, Your Honor.
All right. So we have left the preliminary examination on. The probable cause conference was held, and we'll hold it over for the prelim on February 3rd, 2023 at 9 a.m. Anything else for the record, docket 23-00129, Mr. Wisty?
No, Your Honor.
Anything else, Mr. Hess?
Your Honor, I would respectfully ask Mr. Wisty to confirm that the plea offer I stated on the record is what was extended by the prosecution.
Yes, that is the plea offer.
All right. So we have a full understanding of the plea offer negotiations that have been had, and Mr. Hess will discuss that with you. All right, Mr. Olds?
Yes, Your Honor.
All right. Anything else for the record, Mr. Hess?
Nothing further. Thank you.
All right. That's all for the record, 23-00129. Mr. Olds, we'll see you next week. You're free to leave the Zoom courtroom.
Yes, sir.
Your Honor, if we could address Aaron White, I believe the defendant is here. He had, I don't know if this is the one where he was going to hire Mr. Daly to represent him.
Mr. Daly's here.
Good morning, Your Honor. My apologies. I wanted to mention to the court and counsel that at the time that Mr. White retained us was a transition in our office. Our normal paralegal on criminal matters went out emergently for maternity leave, and it was a couple of days before we got somebody back in to take her place. So we'll take responsibility for the snafu. We are representing Mr. White, and we would ask respectfully for the court's forgiveness for the delay here, and ask the court to adjourn it for a couple of weeks so that I can get the discovery and get ready for preliminary examination. I apologize for the delay.
No worries. Let me grab that file. 2, 3, 4, 5.
Judge, also, we have not entered our appearance yet, but my assistant will do that today. We're waiting for, well, we have the email for Nathaniel Neves, and we'll send it out there.
All right. And your client, Mr. White, is here. Is that true?
That is my understanding, yes.
Is your client prepared to waive his right to a prelim within 21 days in order so that we can have any discovery concerning this case?
Yes, he is, Your Honor. I've not spoken to him about that, but briefly, if I could, it's rather simple, as you know. Mr. White, you have a right to have a preliminary examination within 21 days from the date you're charged. We're asking that you waive your 21 days, not your preliminary examination. You're still going to have that, but the timing within which it's required to be held, I recommend that you waive the 21 days. Are you willing to do so?
Yes.
All right, and I'll walk him through that also, Mr. Daly. Thank you. I'll
Thank
go
you,
ahead and call the case for the record. We'll get started. This is on docket 22-02219. That is People of the State of Michigan versus Aaron White. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
May it please the court, Your Honor, Brian Daly appearing on behalf of the defendant, Aaron White, who stands before this court in person. I am appearing by Zoom. I thank the court for allowing me to appear by Zoom. And both my client and I waive my in-person appearance by Zoom, and I would ask Mr. White to approve that. Is that correct?
Yes.
All right, so you waive your counsel's right. He's available by Zoom today. And you are Aaron White, sir. Is that correct?
Yes, Your Honor.
All right. This is the time set for preliminary examination in the matter. Mr. Wisty, we've already had some discussions on the record, but you can summarize those discussions, your understanding of those discussions.
Your Honor, my understanding is we'll be adjourning this matter today in order for defense counsel to file an appearance, get discovery.
All right, and Mr. White, that's your understanding, correct?
Yes, Your Honor.
All right, Mr. Daly, that's your understanding?
Yes, Your Honor.
All right, Mr. White, Mr. Daly, may I inquire of your client of his waiver of the 21-day rule?
Please do, Your Honor.
All right, thank you. Mr. White, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment. And the preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed the crime in this file. Do you understand that, sir?
Yes,
You,
Your Honor.
of course, are represented by Brian Daly, and he would be present to cross-examine any witnesses brought by the people and contest any charges brought against you at this preliminary examination. Do you understand that?
Yes, Your Honor.
So it is my understanding that you wish to waive your right to a preliminary examination just within that 21-day period. You would not be waiving your right to a prelim. You'd only be waiving it within that 21-day period. And my understanding is for some discovery issues, and so that Mr. Daly can get all the information needed in order to render your defense. Do you understand that?
Yes, Your Honor.
Is it your intent today, and is it your wish to waive your right to a preliminary examination within that 21-day period?
Yes, Your Honor.
Okay, I find the preliminary examination 21-day waiver to be knowing, voluntarily, and accurately made. Mr. Wisty, you also waive your right to a prelim within 21 days?
Yes, Your Honor.
All right. With that understanding, the prelim is waived within 21 days. So the defendant has waived his right to a prelim within 21 days. And we'll get a new date.
February 10th and 8th.
So the new date is February 10th at 8:30.
Is that by Zoom or is that in person, Judge?
That will be in person, because that'll be the date for the preliminary examination.
Will I have enough time to get the discovery between now and then?
Is that 2 weeks? I think that should be 2 weeks.
Judge, if I might
Believe so,
inquire,
Mr. Dick.
could you put it out 4 weeks so I get the discovery and have time to review it with my client?
I might be able to do 3 weeks, but not out to 4.
I'll take 3, Judge.
All right,
Thank you so much.
so let's do February
16th.
February 16th at 8:30. And that should give plenty of time for any discovery or compliance issues.
Yes, sir.
Anything else? And then and as you indicated, you'll be filing an appearance on this file today or tomorrow. Is that correct, Mr. Daly?
It should be filed today. We have the email to send it to, and then we'll send it to the court. Also, we're going to file an appearance on behalf of my associate, Luke Geringer, who will be appearing in this case from time to time.
All right. Anything else for the record in docket 22-02219, Mr. Wisty?
No, Your Honor.
Anything else, Mr. Daly?
No, Your Honor.
All right. Mr. White, please keep in contact with your attorney, Brian Daly, and you are set for February 16th at 8:30. Okay, sir?
Okay.
All right. You're free to leave the Zoom courtroom. Thank you for your appearance today, Mr. Daly.
Thank you, Your Honor.
Mr. White. Thank you.
Hello?
Sir, on the Samsung, would you please identify yourself on the cell phone?
Larry Alford.
Larry Alford. All right. You're in the right courtroom, Mr. Alford. Just stand by, all right?
Yes, sir.
And Miss Young, you're here for your 9:30?
Yes, sir.
Mi- So we're on the record in docket 23-00058, People of the State of Michigan versus Tracy Young. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. John Abbott representing Ms. Young. She appears on video.
And ma'am, you are Tracy Young?
Yes, I am.
All right. Earlier today, I signed a motion to dismiss not what we call a nollie pros. So your case, Ms. Young, is my understanding, has been dismissed today. Is that a true statement, Mr. Wisty?
That is correct, Your Honor.
Mr. Abbott?
Thank you. Yes.
All right. So Ms. Young, you're all set. Your case is dismissed.
Okay, thank you, Your Honor.
You're welcome. So, sir, from the Polycom at Ingham County, can you identify yourself?
Joshua Taylor.
All right. So we're on the record in docket 22-03552. That's people of the state of Michigan versus Larry Dawson Alford. Will the parties please introduce themselves for the record?
Thank you. Good morning, Your Honor. Erin Housefield on behalf of the people.
Good morning, Your Honor. Attorney Derek S. Office of Public Defender on behalf of Mr. Alford. I'm appearing in person here in the courtroom. Mr. Alford is appearing by Zoom.
Sir, you are Larry Dawson Alford.
Yes, sir.
Okay, and you can hear me all right, Mr. Alford?
Yes, sir.
All right. This is the time set for preliminary examination today. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. It's my understanding that the defendant wishes to accept the plea offer that was extended by the people. I know that there were some questions that the parties were looking to have confirmed through the probation office before entering that plea. I don't know which order the court would like to take things in.
I think those questions have been answered for my purposes as far as out-of-state probation. So we can go forward with the plea and continue on. The first step would be Mr. Alford has to come in and go to our probation department while he's here in Michigan. And the second step is to get his fingerprints taken. So with that, I think we're all set. We can go from there. It appears that probation will be through our probation department, but it will be out of state.
Understood. Okay, thank you then. Your Honor, the terms of the plea are that the defendant is going to plead guilty to an added count 2 of use of heroin pursuant to 333.74042A. The maximum penalty on that, Your Honor, is 1 year and or $2,000. The people have no objection to sentencing under 7411 if deemed eligible. There is a sentencing agreement under People versus Killebrew that the defendant will serve no additional upfront jail at the time of sentencing. In consideration for the successful plea and sentence as described, the people would move to dismiss count 1. It is my understanding that the defendant is a resident of the state of Georgia. As indicated by the court, the people have no objection to the probation being handled here or overseen by the probation department here, with the allowance to have him report either by Zoom or email at the discretion of the probation officer. The people do not feel a need to have him in person if he is successfully following through on his conditions. The people would ask that if there are any terms of testing that are imposed as part of probation, that there is just confirmation to the satisfaction of the probation department that the testing done in Georgia is of comparable quality to the facilities and type of testing that would be done here in Michigan.
And I'll restate that for the record, Mr. Etheridge, just so, and then you can correct me. My understanding of the plea agreement is the defendant's to plead guilty to added count 2, but use of a controlled substance pursuant to 333.74042A. That's a 1 year and or $2,000. There's no objection to 7411 status. If the defendant is available to that, there's a Killebrew of no upfront jail, and there's no objection to oversight being done in Georgia, with the understanding that the Lansing Probation Department would send it to Georgia for oversight. Zoom reporting is okay, and any terms of testing that the defendant is required to do has to meet the probation standards of Michigan, or at least the 54A Probation Department. With that understanding, this count 1 is to be dismissed. Is that your understanding of the plea agreement?
Yes, it is, Your Honor. And in terms of some of the other things discussed by the court, in terms of the probation and conditions of probation in Georgia, et cetera, I did discuss that with Mr. Alford. All of that is acceptable to him. I also, per our conversation earlier, discussed him waiving extradition. He did agree to do that. He would ask the court in terms of sentencing to allow him to do his sentencing appear by Zoom, since he does live in Georgia out of state. And in regarding the factual basis, he would ask the court to take the factual basis on the charge count.
Okay, thank you.
Your Honor, may I just clarify one thing, because I want to make sure
All right.
the record is clear. I don't believe that we're sending the case to Georgia for oversight. The oversight will be done here by the probation department. Just any testing that would be done in Georgia would be consistent with testing in Michigan.
Right, and then he'd report by Zoom to a 54A probation officer.
Thank you.
Is that your understanding, Mr. Etheridge?
Yes, it is.
All right. May I inquire of your client of his advice of rights and his understanding of the plea agreement?
Yes, you may, Your Honor.
Mr. Alford, you've
sir.
heard the lawyers talk about the plea agreement, and do you have any questions concerning, for myself or Mr. Etheridge, anything we've talked about?
No, sir. He explained it to me.
Oh, all right. You understand the two conditions of this are A, while you're in Michigan, I understand you're in Michigan, there's just some obstacle in getting you here that while you're in Michigan, you have to report to the 54A probation department. Do you understand that, sir?
Yes, sir.
All right. The second thing is you have to get your fingerprints taken. Do you understand that, sir?
Yes, sir.
All right. You understand that the maximum possible penalty, although we've discussed some Killebrew agreements and other things of the nature, the maximum penalty is 1 year and/or $2,000 for this use of a controlled substance case. Do you understand that?
Yes, sir.
All right. Of course, there have been negotiations in Killebrew no upfront jail. If I don't follow any of that Killebrew agreement at date of sentencing, you of course could withdraw your plea. Do you understand that, sir?
Yes, sir.
All right. So if your plea is accepted today to this added count 2, you will not have any, you will not go to trial and you'll plead guilty. I'm going to walk you through what trial rights you'll waive in order to plead guilty today. Okay, sir?
Yes, sir.
All right. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have a prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses. You, of course, are represented by counsel, Mr. Etheridge. He could contest and cross-examine any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, sir.
You have the right to have the court order any witnesses brought in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Do you understand the trial rights you'll be waiving in this case?
Yes, sir.
If your plea is accepted, you'll give up the claim that the plea was a result of any promises or threats, that it was not your choice to plead guilty. Other than the plea agreement, you'd be pleading guilty today because you are guilty. Is that right, sir?
Yes, sir.
All right. You'd also be giving up any rights on appeal from a trial because you won't have a trial. You're pleading guilty because you are guilty. I'm going to have you raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes, sir.
All right, sir. And it is your intent today to waive all your trial rights in this matter.
Yes, sir.
All right. I'm going to bring your attention back to April 5th of 2021 at the offense location of South Martin Luther King Street in the city of Lansing. Were you on Martin Luther King Street in the city of Lansing on April 5th, 2021?
Yes, sir.
And you indicated that the factual basis would be to the actual charge count 1. On that date at that time, did you distribute? Why don't you tell me what you did that makes you guilty of count 1?
I gave somebody a fake bag of narcotics in order to get
Okay.
some money.
All right. And at the time you gave the bag, you knew it was fake and you're doing it in order to get money for the fake bag of narcotics.
Yes, sir.
All right. Any questions concerning the factual basis, Ms. Housefield?
No, Your Honor, thank you.
Any questions, Mr. Etheridge?
No, Your Honor, thank you.
I find that the factual basis to be understanding, voluntarily, and accurately made. So, Mr. Alford, I'll have you report to probation.
Okay.
Within, if you're here in Michigan by tomorrow by 4. Yeah, so we'll do it tomorrow by 4. So I'll do it January 27th by 4 o'clock, report to probation and answer any questions they have. Mr. Etheridge, go ahead.
I was gonna say you may want him to report earlier, Your Honor, since he has to get fingerprints.
Yeah, that's the latest he can. So let's do it. So so make time to report to probation and make time for fingerprints. You probably should report sooner than that. That 4 o'clock is the latest date because they close at 4, you probably should give yourself 2 or 3 hours. All right, sir?
Yes, sir.
All right, so 4 o'clock, they're closed, so report by 1, just to be safe. If you report by 1, that should give 2 or 3 hours to do everything they need to do. What they'll do is answer any questions. They'll prepare a report for me, and on date of sentencing, we'll address any options you have at date of sentencing. I'm allowing, is there any objection to sentencing by Zoom in this case?
None by the people.
Okay, anything, Mr. Etheridge, on that?
No, we're not regarding sentencing by Zoom. That is our request and desire, Your Honor.
All right, we'll sentence by Zoom, and that date will be
April 11th at 2 p.m.
April 11th at 2 p.m.
Yes, sir.
So your date of sentencing by Zoom, and we'll allow it by Zoom, will be April 11th at 2 p.m. They'll have questions concerning the out-of-state nature of the probation. But at this point in time, you'll be on probation to the 54A court. It'll be supervised out of Georgia. It'll be supervised out of us, but all of your testing matters will be reviewed by us, but it'll be done in Georgia. Do you understand that, sir?
Yes, sir.
All right. Anything else for the record in docket 22-03552, Ms. Housefield?
Nothing for the people. Thank you.
Anything else, Mr. Etheridge?
No, Your Honor, thank you.
Thank you. We're all set. You're all set today. Report to probation by 1 tomorrow. All right, sir?
Yes, sir.
All right. We're all done for the record on that file. All right, we're on the record in docket 23-00059. That is people of the state of Michigan versus Vincent Alvarado. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Good morning, Your Honor. John Abbott with Ingham County Public Defenders representing Mr. Alvarado. He is present and standing to my left.
All right, and sir, you are Vincent Alvarado. Okay, this is the time set for a probable cause conference in the matter. Mr. Whiskey, how are we proceeding?
Your Honor, my understanding is the defense will be asking for an adjournment of the preliminary examination in order to further discuss the case with their client. People have no objection to such an adjournment.
And is that a correct statement, Mr. Abbott?
It is, Your Honor. There's about 100 pages of discovery, which I haven't gone over with them yet. And there may be another witness that I want to interview or preserve their testimony at the preliminary exam. So I'm requesting an adjournment and a waiver of the 21 days.
All right, so your defendant intends to waive his right to appeal within 21 days.
Yes, Your Honor.
May I inquire of your client of his waiver of the 21-day rule?
Yes, thank you.
And I also have here that an order of fingerprints, he has to get his fingerprints. He probably should just get that out of the way today.
Okay.
If he can, he's already here. All right. So, Mr. Alvarado, you understand that you have the right to a preliminary examination within 21 days of your date of arraignment?
Yes, sir.
And your preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime in this file. Do you understand that?
Yes, sir.
You, of course, have a right to counsel at such a hearing. You're represented by John Abbott from the Public Defender's Office. He would be present to cross-examine any witnesses and contest any charges brought against you by the people. Do you understand that?
Yes,
It's my understanding so if you waive your right to a prelim within 21 days, you'll only be waiving your right to a prelim within that 21-day period. You would not be waiving your right to a prelim in general. It's my understanding your intent today, because of discovery and compliance issues, that your attorney has everything he needs to raise a defense. It's my understanding that you wish to waive your right to a prelim within that 21-day period. Is that a true statement, sir?
Yes, sir.
Okay. Mr. Wissy, you also waive your right to a prelim within 21 days?
Yes, Your Honor.
All right. I find the waiver of the 21-day to be knowing, voluntarily, and accurately made, and we will reset the prelim. And this sounds like you need some time.
Week or two.
Okay.
February 16th would be 3 weeks of everything.
The 16th?
Okay.
Okay. February 16th at 9 a.m. All right, we'll reset it February 16th at 9 a.m. Any questions concerning file 23-00059? Mr. Wisty?
No, Your Honor.
Anything else, Mr. Abbott?
No, thank you.
All right, and then if you can get the client fingerprinted today, we'd be all set.
I went and got them already this morning.
Okay, you're all set? All right. All right, that's all for the record. Docket 23-00059. Thank you for your appearance today.
Thank you. We can go do skiing real quick, and then I believe we can do the cloud.
All right.
Duncan too. Come on, Duncan. That'll be quick.
So Steen first.
The reason why I got it.
We can also do Duncan.
All right.
Aaron, are you here on the Duncan list?
So we're on the record in docket 22-03307. People of the state of Michigan versus Glenn Skeen. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And please, the court, David B. Carter Jr. on behalf of Mr. Glenn Skeen, who is not present.
All right. This is the time set for a preliminary examination. It was scheduled for 8:30. It is now 9:57. It appears that the defendants failed to appear today. What's that?
They did not.
Oh, they didn't do a writ?
Yeah.
Oh, that's
They
not,
did.
that's-
They did not go get them.
that's not his fault.
They did, it's my understanding a writ was properly done. However, talking to the jail this morning, they indicated that somehow they got word that our hearing was canceled today, so they did not go pick him up.
All right.
So I would ask the court, because the prosecutor and I have been in negotiation, we believe we've resolved this case. So I do not want a preliminary exam set, but a PCC.
All right.
That
Well-
way we don't have issues with calling off witnesses at the last minute.
All right. We'll set for PCC. Is that your understanding, Mr. Wisty?
Yes, Your Honor, we expected this to resolve at a plea today, as well as I believe last week, but he didn't get it.
All right. So we'll set for PCC, set for preliminary probable cause, and then we have to do, we still have to do a writ out of Clinton County.
Right.
Clinton County. For PCC. And what date?
Your Honor, would you take the plea via Zoom?
Clinton County won't do that.
Yeah, Clinton County won't take the, they won't do anything by Zoom is my understanding.
Would you rather we set this on the statute packet for plea, or do you want it set on the felony?
Either, whatever, do you have a preference as to, one's a Tuesday and one's a Thursday, right?
One would be a Tuesday or one would be a Friday in
Friday.
this particular incident.
Yeah. Do you have a preference as to a Tuesday or a Friday?
Whatever would fit my schedule. If I could have a date, I could check.
Let's try the Fridays first, I mean, and then,
February 10th at 8:30.
does that work, Mr. Carter, February 10th at 8:30?
Yes.
Okay, let's do February 10th at 8:30. That'll be for PCC and plea. Anything else? So, and I'll make sure that, so anything else for the record, docket 22-03307, Mr. Wisty?
No, Your Honor.
Anything, Mr. Carter?
No, you're.
All right, thank you. That's all for the record in that file. And then we have Mr. Duncan. Miss Duncan, I should say.
So Mr.
Mr. All right. So we have two files in regards to Terrell Duncan.
And he has two attorneys. Mr. Carter's on the felony and Miss Robinson.
Which one would you, so if we've got, let's go on the, which file would you like to go on first?
I think if you called them both,
All
it's
right.
gonna be the same issue.
All right. So we're on the record in docket 22-02185 and 22-01904. People of the state of Michigan versus Terrell Shante Duncan. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Mr. Dunkel on the felony file.
Okay, and that would be file 22-01904.
That's correct.
All right, and Ms. Robinson?
Aaron Robinson, Assistant Public Defender for Mr. Duncan on the misdemeanor file.
All right, and that would be docket 22-02185.
Yes, sir.
Mr. Wisty, this is the time set for a review and a preliminary examination in the file. How are we proceeding?
Your Honor, the situation in these cases is both of these files were to be dismissed pending. It's part of a global resolution in circuit court. They were delayed to this point in order for the dismissals to be filed after Mr. Duncan was sentenced. He was scheduled to be sentenced yesterday due to, I believe, some medical issues. Due to some medical issues, he was not able to be sentenced in circuit court. That has been adjourned until 3/15/2023. The people would be requesting both these matters, the prelim be adjourned and the misdemeanor be set for review after that date. It is anticipated that at that time the cases will be dismissed.
Is that your understanding, Mr. Carter?
It is, just for added information, my client was attacked and suffered several broken ribs, was sent to the hospital, and I don't know if he's medicated, but he's basically at home recovering from broken ribs. And
All right.
that is why it got adjourned yesterday.
So, and Ms. Robinson, that's your understanding?
It is, Your Honor.
Okay. So we are awaiting the circuit court sentencing that's been adjourned to March 15th. So we'll adjourn both of these matters to sometime after March 15th.
March 17th.
March 17th at 8:30. And that would be on the, so I'll state it for the record, that's for the review on the docket 22-02185. And on the felony, March 17th at 8:30, adjourned for the preliminary examination. And Mr. Duncan waived his 21-day rule on November 10th, 2022. So we're just setting this for March 17th after the circuit court sentencing. Anything else for the record, Mr. Wisty, in dockets 22-02185 or 22-01904?
No, Your Honor.
Anything else, Mr. Carter?
No, Your Honor.
Anything else, Ms. Robinson?
No, Your Honor, thank you.
Okay, we're all set on both of those files.
Thank you, Your Honor.
Third time's the charm.
That's what I heard.
Don't you have a poll in Clinton County?
Pardon?
Don't you have a poll in Clinton
I
County?
have no poll anywhere.
And then we can move Matthew McLeod.
All right, it's so Mr. McLeod is here on a probable cause, 4 probable cause conferences and a sentencing. What's that? No, is that? It's Joshua. So I don't know where is Mr. McLeod not here?
He's in custody here.
All right, so
Wendy, can I take a look at his misdemeanor?
let's find out if there was, I believe Monday he was on suicide watch.
Yes.
And so that's
That's
the,
correct.
yeah, so let's see where he's at. How about,
Where he was last night, Your Honor.
what's that?
That's where he was last night. when
That's
I
where he was last night. We may have our answer, but let's see. And then Mr. Taylor is, right, he's on Polycom, and that's, who's representing Mr. Taylor? Mr. Taylor, we'll be with you in just a second. Your attorney's in another courtroom right now, okay?
Okay, sir.
All right, thank you.
Yes, sir.
We're on the record in docket 22-00275. People of the state of Michigan versus Asen Austin Moxley. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Edward Hess on behalf of Mr. Moxley. Mr. Moxley has appeared in person today. Your Honor, may I please approach the bench with an advice of rights?
You may.
Thank you.
Thank you. You're very well. And sir, you are, and you correct me on the pronunciation, Asen Austin Moxley?
Yes, Your Honor.
All right. This is the time set for a probable cause conference. Mr. Wisty, how we proceed?
Your Honor, we've reached a resolution where the defendant will plead guilty to an added count 2 of larceny less than $200. That is PAC code 750.3565, 93 days and or $500, or 3 times the value of property, whichever is greater. To impose a fine of 3 times, the defendant must admit the amount, or it must be determined by the trier of fact. With that, we have a restitution agreement to be paid to the state of Michigan. Amount
$188.70.
$188.70. Thank you. And in exchange for that, count 1 would be dismissed.
Okay.
And also on the sentencing of that to no offense, really.
All right, I'll restate the offer as I know it, and Mr. Hess, you can correct me if I've missed anything. My understanding is the defendant is going to plead guilty to an added count 2 of larceny under $200 pursuant to 750.3565. That's a 93-day misdemeanor and or $500 or 3 times the value. There's a restitution agreement of $188.77. There's a Killebrew agreement of no upfront jail, and count 1 is to be dismissed.
That is correct.
All right.
Just for the record, it's $188.70.
And 17 cents?
70.
70. Okay, thank you. And as Mr. Moxley, is that your understanding of the plea offer?
Yes, Your Honor.
Mr. Hess, may I inquire of your client of his advice of rights and his misdemeanor rights in this case?
Yes, certainly.
All right. So you understand the maximum penalty that the court could issue in this case, Killebrew agreement aside, is 93 days and or $500 or 3 times or the fine being 3 times the value of the property. Do you understand that, sir?
Yes, Your Honor.
Right. Of course, if I didn't follow the Killebrew agreement, you could withdraw your plea in this case. You understand that?
Yes, Your Honor.
There's a Killebrew agreement and no upfront jail. There's a restitution agreement of $188.70, and count 1 is to be dismissed as you'll be pleading guilty to count 2. Is that your understanding, sir?
Yes, Your Honor.
All right. You've signed this advice of rights that I'll place in the file concerning your trial rights in this case. Is this the advice of rights that you signed?
Yes, Your Honor.
Okay, so you're waiving those rights in this case. I will indicate for the record that you have 3 constitutional rights, and we'll talk about those, all right?
Okay, Your Honor.
First of all, you have the right to the presumption of innocence, and you have the right to that the people prove beyond guilt, beyond a reasonable doubt that you are guilty in this case. Do you understand that?
Yes, Your Honor.
You have the right to counsel in this case. You, of course, are represented by Mr. Hess, and he would cross-examine and contest any witnesses brought against you. You understand that?
Yes, Your Honor.
You also have the right to silence in any trial, and you have the right not to have that silence used against you in a court of law. Do you understand that?
Yes, Your Honor.
All right. With that understanding, is it your intent and wish to waive your trial rights in this case and plead guilty to this charge, which is count 2 larceny under?
Yes, Your Honor.
All right. I'm gonna go ahead and have raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes, Your Honor.
All right. I'm gonna bring your attention back to February 1st of 2021 at the offense location of Allegan in the city of Lansing, Ingham County. Were you on Allegan Street in the city of Lansing on February 1st, 2021?
Your Honor, if I may clarify.
Sure.
Mr. Moxley, did you engage in an online financial transaction with the Secretary of State, which is located at 430 West Allegan Street, City of Lansing, on the date that the judge mentioned?
Yes, Your Honor.
Right. And so you were on that date and at that time, and at that time in count 1, essentially, you engaged in online behavior in which you used somebody else's PIN number, somebody else's device with the state of Michigan in order to get some type of services concerning count 1.
Yes, Your Honor.
All right. And at the time, you knew what you were doing was wrong in regard to you unlawfully using that device or that PIN number in order to claim that somebody else did it, and you knew that it was wrong at the time.
Yes, Your Honor.
All right. So that any questions concerning the factual basis, Mr. Wisty?
No, Your Honor.
Any questions concerning the factual basis, Mr. Hess?
Mr. Moxley, are you stipulating to the restitution amount of $188.70?
Yes.
No further questions, Your Honor.
Thank you. All right. I find the plea to count 2, which is larceny under 200, to be knowing, to be understanding, voluntarily and accurately made. Mr. Wisty, because of the restitution, did you want this referred to probation?
I would leave that in the court's discretion. This is a relatively minor charge pled down to it that started as a felony. There is a history here involving some other, he's got several misdemeanors on his record.
Let's refer to probation. So we'll refer to probation in regards, we have restitution in the matter. We have some prior history. So I'd like to take a look at what options are available for you at sentencing. So today, while you're here, you might as well go down to the 5th floor to the probation department and answer any questions they have they'll prepare a report for me. We're looking at probably early April to see what options are available in regards to staying with the plea agreement and seeing what's available to us in regards to programming. Do you understand that, Mr. Moxley?
Yes, Your Honor.
All right. So refer to probation, sentencing date,
April 11th at 2 p.m.
April 11th at 2 p.m. In this misdemeanor plea, you understand, we don't have sentencing till April 11th. So the best thing you can do right now is stay out of trouble so that I don't get any new reports concerning anything else up until that date. Does that make sense?
Yes, Your Honor.
All right. Anything else on the record in docket 22-00275, Mr. Wisty?
No, Your Honor.
Anything else, Mr. Hess?
Nothing further. Thank you.
All right. We will see you on that April 11th date. All right, Mr. Mox?
Thank you, Your Honor.
All right.
Thank you very much, Your Honor.
And there's also. We're good. Thank you.
Thank you, Your Honor.
Thank you, Julie. Prince. We'll see you, Mr. Hess. Thank you.
Thank you, sir.
There's nobody. Are we ready on Mr. Drain?
Yes, Your Honor.
All right. All right, we're on the record in docket 22-01717. That's people of the state of Michigan versus Michael Drain. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Angela Del Vero on behalf of the people.
Good morning, Your Honor. Jacob Starks, fourth Assistant Public Defender here on behalf of Mr. Drain. Mr. Drain is present at council table. He's standing to my right.
And sir, you are Michael Drain?
Yes, Your Honor.
All right. This is the time set for a preliminary examination on the matter. Ms. Del Vero, how are we proceeding
Your
today?
Honor, today's the date and time set for a preliminary exam, as the court has just indicated. It's my understanding that the defendant will be waiving preliminary exam. However, the people will be asking the court to, well, I guess I'll ask the court how procedurally the court wants to deal with this. People are moving to add a count of assault with intent to commit penetration and to amending the habitual fourth enhancement to be the quote unquote violent have for that has a mandatory minimum of 25 years. It's my understanding the defendant has no objection to those amendments and will continue to waive preliminary exam even on those amendments. So I foresee two different ways we can do this. I could file the paperwork here and then we would do an information in circuit court that matches what I filed here, or he could waive on what's currently on the information and we could agree that I would file an amended information in circuit court.
I think it's probably cleaner if he waives on the information in front of the court because I lose jurisdiction once I send it to circuit court. And it sounds like this is an amended information in circuit court.
That's fine by me if that's how Mr. Starks is.
Mr. Starks, does that meet with your agreement?
That's fine.
All right.
With the assault with intent to commit penetration, I do not believe that Mr. Drain would be entitled to request a preliminary examination, even if the prosecutor requested it down the road, because that has a 10-year tail.
Correct.
Versus the two 15-year counts. And as for the super have notice, the prosecutor, of course, would be free to amend that portion pretty much at any time. So that's why the defense is at this time would not contest the amendments, and we'll leave it to the court's discretion, and that's fine. We can address it in circuit court.
All right. So you'll follow the amended information in circuit court. And I do think Mr. Starks is correct. The assault with intent to penetration is a 10-year. These are both 15 years, so essentially a lesser offense on some level. Mr. Drain, do you understand that today you are waiving on this information in front of me? You'll be in circuit court where amended information has been filed that Mr. Starks has talked to you about.
Yes, Your Honor.
All right. With that understanding, may I inquire your client of his waiver of his preliminary examination?
Yes, Your Honor.
Okay, it's my understanding, Mr. Drain, that you intend to waive your right to a preliminary examination today. Is that correct?
Yes, Your
All right. You understand that you have the right to preliminary examination in this file in this courtroom, in district court, and that preliminary examination is a probable cause conference, probable cause. The prosecutor would have to prove by probable cause that a crime has been committed in this file and the identity of the person who committed that crime. Do you understand that, sir?
Yes,
You, of course, have the right to counsel during such a proceeding, and Mr. Sartz would be available to contest any charges and cross-examine any witnesses brought by the people concerning this information. Do you understand that, sir?
Yes, Your
It is my understanding that negotiations are going to continue in circuit court. They're going to amend the information in circuit court, but on this file, in this court, you're going to waive your right to a preliminary examination today. Is that correct?
Yes, Your Honor.
Right. Do the people also waive their right to a preliminary examination?
Yes, Your Honor.
All right. I believe the waiver to the preliminary examination be freely, understandingly, and voluntarily made. Negotiations are to continue. And you will get your time here in district court is done. And you're now in the trial court, which is circuit court. You will get any new date from your attorney, Mr. Sartz. Circuit court will set that date for arraignment or pretrial or what have you. You'll get that from Mr. Sartz, all right?
Okay, thank you.
All right. Do you have any questions or anything else on docket 22-01717, Ms. Delvero?
I think what I'll do is I'll file this information and then an amended in
Okay.
circuit court, because I think they'll be expecting this information to come first. So that's how I'll do it.
All right. And Mr. Sartz, no objection to that?
No objection to that, Your Honor.
All right. With that understanding, any further question on 22-01717 from you, Mr. Sartz?
I would just like to be heard on bond.
Okay. So before I waive it up to district court, you can make your motion on bond.
Thank you, Your Honor. Mr. Drain has a somewhat complicated situation going on in Saginaw, and right now he's been continuously lodged for an extended duration, Your Honor. I expect in the short term, at least, he will still remain in Saginaw. But in the event that it takes an extended period of time before Mr. Drain eventually sees a trial date on this matter, and this case is quite complicated, Your Honor, I would request the court consider reducing his current cash bond amount at this time. Mr. Drain, if he is able to bond out eventually, would have a safe and a stable place to stay. Mr. Drain can update the court as to what his release address would be. He is a younger man. He would like the opportunity to potentially get out, possibly pursue some employment or educational opportunities. He would not be flight risk at all. He has a good record of making his previous court appearances. He can comply with all the court orders. There's no allegations, to my knowledge, of any alleged, PA 53 issues or other concerns while he's been lodged. Your Honor, he would be able to participate either by Zoom and certainly he can get transportation to make sure that he appears at all his in-person court dates as well. So he's familiar with the area. Transportation won't be a problem. I don't anticipate, Your Honor, that in the short term, he'll be able to get his release. This is more so for longer term, and I'm asking for this reduction. Thank you.
Thank you. Ms. Delvero, motion for bond in this case.
Your Honor, at this time, I would oppose any reduction in bond. The defendant has an extensive violent criminal history, which is the court can probably infer, given that the people will be amending the HAB 4 to the super HAB. He has a 2018 conviction for home invasion third, retail fraud third in that year, 2020 MDOP misdemeanor, 2020 RNO, 2020 felonious assault, a 2021 DV OWI and attempt UTA. He was on probation for the RNO and FA at the time of these offenses are alleged to have occurred. He has started a probation violation hearing in Saginaw on that probation violation, where the victim in this case has already testified at that preliminary hearing, probation violation hearing. It's my understanding defense counsel in that probation violation asked for an adjournment after her testimony, and court date has not been rescheduled. He also, while in custody in Saginaw, awaiting the adjudication of that probation violation in 2021, was charged with and convicted of possession of contraband in the Saginaw County Jail. He has previously been a probation absconder on that probation, cutting off a tether
previously. This is not a person who has demonstrated to the court that he can follow the directives of a court, and I would ask the court to deny any motion for bond.
Based on the statements made by the prosecutor in relation to the court rule of prior criminal history, safety to the community, and failed to appear, the court's going to deny the motion for reduction in bond. Anything else for the record in docket 22-01717, Ms. Delvero?
Nothing, Your Honor.
Anything else, Mr. Sarts?
Nothing further. Your
All
Honor.
right, thank you. Your time here in district court's done, sir. Okay. And Mr. Sarts, he'll sign the waiver.
Does the court need me to sign the waiver now, I think?
On some forms,
Okay.
not on that one. So we're on the record in docket 20-03373. That's people of the state of Michigan versus Joshua Taylor. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Taylor, who is present via Zoom at this time, Your Honor. He's in ICJ right now.
And sir, you are Joshua Taylor?
Yes, Your Honor.
And you can hear me all right, Mr. Taylor?
Yes, sir.
All right, this is the time set for a probable cause conference in the matter. Mr. Wisty, how are we proceeding?
Your Honor, this time we'd like this left on for the preliminary examination next week. And I believe the defense has a motion concerning bond.
Okay, so the PCC is held and this is left on for preliminary examination, which would be on February 3rd at 9:30. In regard to that information, is that an accurate statement, Mr. Mills?
That is, Your Honor. I would just like to say, just regarding this, Your Honor, that was very recently appointed. Mr. Palmer was originally on this. Mr. Palmer and I have switched courts at this point, and so that's only the last minute delay here. So we apologize for that, Your Honor. But yes, we'd like to leave it on for preliminary examination next week. I have full confidence that we will likely be able to resolve this, though, Your Honor.
All right, thank you. And then, Mr. Milks, would you like to be heard on bond? Bond is set, in my understanding, was set on January 18th at 4,010%. Is that correct?
Yes, Your Honor, that is correct.
All right, you may proceed.
Thank you very much, Your Honor. Your Honor, at this time, my client is unable to afford that bond amount. Understanding the court may see that amount is reasonable for my client. It's not something that he could actually pay at this time. So we are asking that the court consider a PR bond, Your Honor, with conditions, specifically that he put on a GPS tether. I believe there is some funding for that that should be available to him. And if released, Your Honor, it's my understanding he will be living with his mother, who is a responsible member of the community and has a very strong interest in him maintaining his ongoing health and sobriety, Your Honor. The family does have a very strong interest in that. So I believe he's a responsible member of the community over him. So if the court would consider that, Your Honor, and the fact that we are looking to likely resolve this matter, we would ask the court consider a PR bond at this time. And thank you.
Thank you. Mr. Wisty, I'm looking at the previous history. These aren't my notes. It appears there was a failure to appear previously at a probable cause conference in front of Judge Alderson.
Yes, Your Honor, this case is rather old. The reason for that, it looks like there was a failure to appear in May of 2021. And that's why we're here today. The defendant had a bench warrant for that period of time. There's also there's a city case involving, I think, driver's license issue. The case pending, both of them are pending in this court involving the same defendant. The other one is a dog license issue that were also with bench warrant status from approximately the same time. There's a criminal history here. It deals with primarily low-level domestic violence and substance type offenses. Previously, it's been alcohol and marijuana. The last one is 2017. So that is the lay of the land, Your Honor.
All right, do you have an objection to?
I would leave it in the court's discretion. I think there's a chance, and we're taking a risk that he's not going to appear for court based on that history of this.
I agree. I'm going to deny the motion at this time and revisit. Then I'll ask counsel to revisit this a week from today. So we'll see what the ultimate outcome in the case is. But at this point in time, I'm going to deny the motion, and we'll see where we are a week from today in order to take a look at the resolution of the case. But that is, most of that is because we've had a failed to appear previously, and we're 2 years later, and I want to make sure he appears for court. Anything else for the record in docket 20-03373, Mr. Wisty?
No, Your Honor.
Anything else, Mr. Mills?
No, Your Honor, it's very generous and we appreciate it.
All right, thank you.
I'll be in contact with you soon then. Okay, Mr. Taylor?
Yes, sir.
All right, thank you, sir.
You're all set, Mr. Taylor. We'll see you next week.
Okay, thank you, Your Honor.
We'll see if they And so who's ever there at the jail will assign Mr. McLuth to room 1 to be with his attorney. I don't know if, but I'm not certain if that comes up on the pad or if somebody has to help you go to the assigned room. How does that work to put them in a room? All right, so we're on the record in docket 23-00142, People of the State of Michigan versus Catherine Alvarez Matos. Will the parties please indicate their presence for the record?
Jake Westy on behalf of the people.
Good morning, Your Honor. Stephen Milks on behalf of Ms. Alvarez Matos, who is appearing via Zoom at this time and was waiving her in-court appearance.
And ma'am, you are Catherine Alvarez Matos?
Yes.
Okay, and you can hear me all right, Ms. Alvarez Matos?
Yes.
All right, this is the time set for a probable cause conference. Mr. Wisty, how are we proceeding?
Your Honor, it's my understanding defendant will be waiving up today, waiving the right to a preliminary examination. The people also waive their right. Both waivers will be unconditional. Negotiations to continue in circuit court.
And is that an accurate statement, Mr. Milks?
That is an accurate statement, Your Honor, and we are looking towards a global resolution on matters that she already has upstairs, including potential for mental health court.
All right.
That is correct, Your Honor.
Mr. Milks, may I inquire of your client of the waiver of prelim?
Yes, Your Honor. Thank you.
All right. Ms. Alvarez Matos, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment. Do you understand that, ma'am?
Yes.
And a preliminary examination is a probable cause hearing in which probable cause must be proven by the state that a felony was committed and the identity of the person who committed that crime. Do you understand that, ma'am?
Yes.
Okay, it's my understanding, and you, of course, are represented by Stephen Milks for purposes of preliminary examination in district court. He would be here to contest any charges or cross-examine any witnesses brought against you. Do you understand that, ma'am?
Yes.
It's my understanding that you wish to waive your right to a preliminary examination. That's an unconditional waiver, and that negotiation between the parties are to continue in circuit court. Is that your wish and intent to waive your right to a preliminary examination today?
Yes.
All right. I find the waiver to the preliminary examination to be freely, understandingly, and voluntarily made. We've discussed that negotiations are to continue. Mr. Wisty, the prosecutor also waives their right to preliminary examination?
Yes, Your Honor.
All right. With that understanding, I'll bind this case over to circuit court. On all charges. And you will get your next date in circuit court in the trial court from Mr. Milks. All right, ma'am?
Yes.
All right, thank you. Anything else for the record in docket 23-00142, Mr. Wisty?
No, Your Honor.
Anything, Mr. Milks?
No, thank you, sir.
All right. We'll have you sign the waiver. You're all set, ma'am. You'll get your next date from your attorney, all right, ma'am?
Thank you.
Thank you.
We're the only ones left. Oh, okay, cool.
Oh, okay.
Does that have the place for him to sign? The new?
Yeah.
Depending on what?
Come back.
So we're on the record, and I want to make sure that in docket 23-00143. So 143. 22-02899. 22-03218. And 22-01922. That's people of the state of Michigan versus Matthew McCluth. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. McCluth on those files.
All right. And this is the time set for a probable cause conference. Sir, you are Matthew McCluth?
Yes, sir.
All right. And you can hear me all right, Mr. McCluth?
Yes, I can.
All right. Thank you. This is the time set for a probable cause conference. Mr. Wisty, how are we proceeding?
Your Honor, my understanding is the defendant will be waiving up to circuit court, waiving his right to a prelim. The people will also waive their right to a prelim. Waivers will be unconditional. Negotiations to continue in circuit court. And on file 23-00143 FY, I guess the people would be amending the complaint and then filing the information in accordance with the correct spelling of defendant's last name.
All right. And is that 143?
Yes.
Yeah. So I'm going to, at the PCC, and this is an unconditional waiver. Any objection to me amending the name for the file?
No objection.
Waiver. I'll amend the spelling of the name of Mr. McCluth to, right, it's MCLOUTH.
Yes, Your Honor.
H. So I'll amend that for the record. Okay. As to all of these files, Mr. Abbott, it's my understanding you heard Mr. Wisty speak. Is it your intent to waive your right to a preliminary examination on all these files with negotiations to continue in circuit court?
It is, Your Honor. I did speak with Mr. McCloud yesterday evening, and we discussed it, and this is the best way forward, I think, especially if the potential for some mental health services available in 30th Circuit.
All right. May I inquire of your client of his waiver on these files? And I'll indicate that we're addressing all the files. I'll state them for the record, but may I address your client in regards to the waiver of the files?
Yes.
All right. Mr. McCluth, you understand you have a right to a preliminary examination in all these files, and I'll state it for the record. You have a right to a preliminary examination in 23-00143, 22-02899, 22-03218, and 22-01922. You understand you have a right to a preliminary examination within 21 days of your date of arraignment in all these files. Do you understand that, sir?
Yes, I do.
I can't, you're gonna have to say that again. Maybe move up a little closer.
Yes, I do, Your Honor.
Thank you. And a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed in each one of these files and the identity of the person who committed that crime in all these files. You, of course, are represented by John Abbott, and you have a right to counsel. He would be present to contest and cross-examine any witnesses concerning all these files in regards to your defense. Do you understand that, sir?
Yes, I do, sir.
It is my understanding that you wish to waive your right to a preliminary examination on all these files unconditionally and have negotiations continue in circuit court. Your time in district court will be done. Is it your wish today to waive your right to preliminary examination on all these files and go forward in circuit court?
Yes, I do.
All right, thank you. I find the waiver of the right to a preliminary examination to be freely, understandingly, and voluntarily made. We've discussed the plea agreement. The negotiations are to continue. Mr. Wissy's indicated that he waives his right to a preliminary examination concerning all these files. And so I will bind all these files over to circuit court on the complaints in the files. And your next date in circuit court, you'll get from your attorney, John Abbott. All right, sir?
Yes.
All right. Anything else for the record in any of these files, Mr. Wisty?
No, Your Honor.
Anything, Mr. Abbott?
Not today, thank you.
All right, thank you. That's all for the record in these files. Mr. McLuth, you've got one sentencing left, so stay there. And then if we want to have him sign it, let me, I can give them to you and you can have them sign. I still got to make notes. All right, and we're on the record in docket 18-0568. That's people of the state of Michigan versus Matthew McLuth. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Aaron Robbins, Assistant Public Defender for Mr. McLuth.
And this is the time set for a sentencing in this matter, in this use of cocaine matter. Mr. Wisty, you've had the opportunity to read the pre-sentence report?
Yes, Your Honor.
All right. Ms. Robinson, you've had the opportunity to read the pre-sentence report and go over it with your client.
I have,
All right. Any additions, deletions, or corrections?
not at this time.
Allocution.
Yes, Your Honor. After reading the report, I think it's clear that Mr. McLuth likely suffers from some substance use issues as well as some mental health issues. However, at this time, I'm not sure probation is the best bet for him, simply because of the fact that he has some other felony cases that were just found up to circuit court in this matter. And I think the goal for those cases were to get him involved in some more robust mental health services. From my calculations, it looks like he has about 20 days in custody on these cases. So I would ask that he be sentenced to time served on this matter. He does still have a bond on those felony cases. He would not be getting out and likely probably wouldn't be getting out until there's a plan put in place to meet the needs for Mr. McLuth. I just don't want this to get in the way of that going up to circuit court when obviously those needs will be better addressed.
All right. Mr. Wisty, do you have any comment that we just bound over 4 or 5 counts?
I agree with defense, Your
Right.
Honor. I think in interest of resources, he's going to be on bond conditions anyway, which will cover a lot of this until the circuit court case is resolved.
So I'm not going to adopt the recommendation and I'm not sure, but we have 1, 2, 3, 4 felonies that have been waived up to circuit court. Negotiations are continue. There's obviously the mental health treatment and the mental health court involved in this. This is a 1-year controlled substance. And if I remember correctly, there is a extensive criminal history here, or somewhat. But I didn't see, well, there's one aggravated assault, which would be an assaultive crime. But I do find, because of the other pending matters, that it doesn't make any sense to have probation when you're duplicating, which is going to be another source of this. So I am going to find the defendant. This is in regards to the controlled use of controlled substance guilty plea that was had on January 11th, 2019. It is the order that the defendant spend 20 days in the Ingham County Jail. Credit is given for 20 days previously served. I'll make sure and initial that.
You can just write down
Okay,
the
all right. And I'm gonna waive fines and costs. There is a crime victims' rights fee of $75, a state minimum cost of $50. We won't be doing probation in the matter. What's that? Yeah, I'm probably going to, yeah, let me sign this here. But you're right, I'm not. I'll write my rulings on the ROA that the judgment is sentence is 20 days in jail, credit for 20 days served. I'm going to waive fines and costs. $75 crime victims' rights fee, $50 state minimum fee for a full cost of $125. I'll administratively close this file. And we will not have any probation. On the matter. And that way they can start afresh in circuit court. I'm going to cross out probation. Anything else? So, sir, your sentence is 20 days in the Union County Jail, credit for 20 days served. I've waived fines and costs. You have $125 to pay that is going to be administratively closed at this point. You're not on probation, understanding that in circuit court, they'll start this process over again on the 4 or 5 felonies, 4 felonies that you waived on today, depending on what happens with those cases. Do you understand that, Mr. McLuth?
Yes, I do.
All right. Any questions, Mr. Wisty, on docket 1807568?
No, Your Honor.
Any questions, Ms. Robinson?
No, Your Honor, thank you.
All right, thank you. That's all for the record in that file. That went faster than I thought today, huh? And Mr. McLuth, you're all set. You're free to leave the Zoom courtroom. All right, sir?
Okay.
Thank you.
I do got a question. The jail hold on me, they're trying to get my mental stuff that going right now.
I'm gonna turn it up.
I was wondering if, how would the whole jail hold thing go with them trying to get me placed in a mental hospital?
I don't know the answer to that right off the top of my head. It's my understanding that the sheriff himself is filed a PRT, a person requiring treatment petition. And they intend to find a place for you to get mental health treatment. I guess I'll have to seek guidance at the circuit court level probably next week to get that modification of your bond.
Right. Because you're in a different court now.
Yeah.
Okay, I was just wondering.
All right, well, I'll get it sorted for you as soon as I can, okay?
Okay. Have a nice day.
Thanks.
Thank you.